It was a beautiful spring evening in New York. A warm breeze drifted down the streets, and the late evening sun was retreating below the skyline. Idling limousines were double parked around the block of Park Avenue buildings, where the Wall Street titans, socialites in mink coats, corpulent art dealers, and waif-thin models poured into the building to attend a spring gala in the penthouse above. Once inside, guests were greeted by black-suited waiters proffering trays of champagne followed by mounds of foie gras and smoked salmon. The event glowed, saturated by the joy of spring. But in one corner, the back room, two guests huddled, deeply engaged in a discussion that was anything but festive. The voice of one rose in uncontainable fury, turning the heads of others around him. It's my painting. The gallery is supposed to sell it for me, but never paid me a penny. Now someone else has it, and I'm told I have no rights to it. I lost my painting, and now I've lost my money, and I'm not being paid for it. Well, could any of you be in that position one day? Let's hope not. But the transaction and agreements that led to this unhappy partygoer's furor are probably the same as transactions and agreements that most collectors engage in. So thank you. It's great to be here. Good evening. I am Dean Nicyper, and I thank Miriam and Rago Arts for inviting me to this wonderful event in this beautiful setting. This is my first time down at Rago, and I've heard a lot about it from many people and many collectors. And who speak fondly of Rago. So it's great to be here. So tonight I'm here to discuss a little bit about the rights and risks when transactions go awry. I want to thank everybody here. I also want to get out of the way a couple of preliminaries, that nothing I say tonight should be considered legal advice. Any opinions or statements are not the opinions or statements of Rago, nor of my law firm, Flemington Black Williamson. In fact, they're not necessarily my own opinions either, but I sometimes use them for illustrative purposes. So let's begin tonight by discussing art consignments and why sellers should beware of hidden risks when they consign works of art. A consignment in the art world often involves the owner of a work of art, such as many of you may be, engaging a dealer or an auction house to sell that work of art. The discussion tonight will focus more on art dealers and art galleries rather than auction houses, because really the main arenas of the interesting legal developments are more in the art dealer and art gallery arenas. Consignment to a gallery or a dealer usually involves the owner delivering a work of art to the dealer so that the dealer can show it to potential buyers. In a sale, the dealer will receive some commission or a share of the proceeds. The consignor-dealer relationship usually begins as a very friendly one, and both optimistic about the outcome of the transaction, and quite frankly, 99% of the time, the relationship also ends very friendly. So let me be clear, the vast majority of dealers and galleries are upstanding merchants. They are the art business because they are devoted to the art. The stories I will tell tonight, of course, focus on a few bad apples, but they are not the majority of the art dealers out there today. But because there are a few bad apples, you should be aware of risks that do not always reveal themselves beneath the haze of the initial friendliness and optimism when you begin a consignment. What are everyone's rights, for example, when the art dealer runs into serious financial difficulties? When that occurs, what are the rights, or what rights does a collector have in a work of art it consigned to a dealer if the dealer fails to pay the selling collector? Can a dealer's bank or other creditors have rights to that work of art that are actually superior to the selling consignor, the person who owns it? Can a purchaser who pays full value to the dealer have rights to the artwork that are superior to those of the original owner who sells it, even if that owner and seller has not been paid by the intermediary? Now, the answer to these questions may be surprising to many people. A buyer who pays a dealer full value for a work of art, if she has no reason to think there's anything nefarious about the transaction, often will have better rights to the work of art than a seller who is not paid by the dealer. Now, you might ask, how can that be the case? That's because under the law, in most circumstances, when a collector delivers a painting or other work of art to a dealer, the dealer has the legal ability to transfer title to the purchaser. It's often described as having the ability to transfer whatever rights the collector had in the work of art. This often means that if a buyer pays full value for the art and has no reason to believe there's anything afoul in the transaction, the buyer will end up being the owner of the painting. In that situation, even if the selling collector is never paid by the dealer, the seller cannot recover the painting or any money from the buyer. The seller's left to try to go after the dealer, and quite frankly, if the dealer's bankrupt and doesn't have money, the seller is out of luck. So let me describe a few, or a couple of fairly extreme applications of this rule that may surprise you. Let's say a dealer approaches a collector and tells her he has a ready buyer who's ready to pay $10 million for her John Singer Sargent painting. She loves the painting and she has no desire to part with it, but she paid $5 million for it, and a $10 million offer is really more than it's really something she cannot refuse. So with tears in her eyes, she goes to the dealer with losing one of her great loves, and she allows the dealer to take the painting and show it to the willing buyer. Now the dealer here, although normally ethical and with very good long-standing reputation, recently has been down on his luck and needs to turn some quick deals to get back in the black. In this instance, he actually never had a buyer willing to pay $10 million. But because it's such a fine painting, he thinks he'll be able to find something. Unfortunately, the market is not as high on the painting as he is, and he finds several interested buyers, but the highest price he can get is $5.5 million. So desperate for cash, he makes the sale. He has many debts to pay, so he tells the seller that he sold the painting, sends her $2 million right away, says he'll pay the rest soon, and eventually he does pay another $500,000, but never pays a penny more. So in that situation, there's no question, the dealer clearly defrauded the seller. He fraudulently induced her to part with a painting she loved that she would never have parted with for $5 million, and certainly not for the $2.5 million she ended up receiving. So because the dealer defrauded her, obviously, she can nullify the sale and get her painting back, right? Wrong. In this situation, the court is likely to rule that the buyer who paid good value for the painting has better rights to it than the seller. The seller is left to try to recover from the dealer. If she cannot do so, just like the collector in my opening vignette, she loses her beloved painting and loses all of her money except maybe the $2.5 million that she paid. Let me go to another example. The same seller owns a wonderful Lichtenstein painting, which she bought at an auction for a great price. Some say it was Lichtenstein's greatest work. She has a relationship with a new dealer now, who's very successful and even owns the entire building where his gallery is located in New York. She learned from her past debacle in selling Sargent painting. So this time, she tells the new dealer she will not deliver the painting to him unless and until he actually delivers to her the full amount that she wants for selling the Lichtenstein. The dealer tells her it's not necessary to do that, that's not common in the business, this Lichtenstein is terrific, we really could probably get more than you're asking, you don't need to get the money up front. She says, no, I'm standing my ground this time. I've already been burned, and she insists that he pay the full purchase price. So the dealer hands her a check for the full price, and she delivers the painting to him, and she happily deposits the check in her bank. 1 week later, however, the bank contacts her and tells her that the check has been dishonored for insufficient funds. She's outraged. She bursts into the gallery, demanding her painting back. She finds the gallery, however, is nearly empty. The reception is laid off. The gallery owner is packing up a few things that are remaining. He apologizes for the bounced check, but says he was unable to keep up with the mortgage on his fancy new facility where the gallery is located, and that the bank foreclosed on the property and foreclosed on all of the inventory, including work that had been pledged as collateral on the loan. And he explains that her Lichtenstein painting was one of the paintings that the bank foreclosed on. She has a thought, however. Because the dealer's check bounced, he never really owned the painting, and she, of course, can demand it back from him, right? Wrong. It is terrible and unusual. Usually in circumstances like this, where a bank accepts works of art as collateral for a loan, its right to the artwork is superior to the rights of the consignor, even if the check the dealer gave bounced. Creditors like a bank in this example are generally treated the same way an innocent buyer is treated, who pay value for art. This rule applies not only to collateral owned by the gallery, but also to works of art that are on consignment to the gallery. That's the rule of law. So somebody said that's terrible, and one wonders, well, why is it that this rule of law is so unfair to sellers? Well, look at the transaction from the other side. So if you were the buyer, say, of that wonderful John Singer Sargent painting, you paid $5.5 million for it. Should you lose the painting and lose your money? The difficulty is, as one court put it, there's a difficulty inherent in resolving competing claims. And the difficulty is that the villain of this story has left the stage permanently. An insolvent dealer is in no position to make the parties whole, and it is up to a court to determine between two innocent parties who should bear the risk of loss. So, now you've all gone to law school, and you have some idea about this. I do want to put one other factor in here, and that is, this is a nuance. So far we've been talking about what happens when a consignor consigns a work of art to a dealer, and the dealer sells it to another private collector. But what happens when the buyer, in fact, is not just a private collector, but is a dealer himself? Interestingly, there, a different standard applies. Art dealers are held to a higher standard of inquiry when they buy. And as a result, a selling collector might actually have better rights if the buyer is a dealer than the seller would have if the buyer is just a private collector. You'll recall that we previously said that an individual collector who buys from a dealer can trump the rights the dealer did not pay. But remember, that's where the buyer is a collector. The buyer is a merchant. He must investigate the provenance of the painting much more than a buyer who is not a dealer. The buying dealer is required to undertake due diligence investigation, and if there's anything unusual or suspicious in the transaction, there's an obligation to investigate even further. So now, you're fully versed in the law. So let me describe a couple of real-life situations and cases that I've handled. The first concerns an individual named Michelle Cohen. Michelle Cohen was an art dealer. He developed a terrific reputation over 15 to 20 years. He became particularly well known for selling Picassos over time, and also for selling Chagalls. He was known by and did deals with almost all of the major dealers who handle Impressionist and modern art. He became very successful. He was married. He had 2 kids. By the late 1990s, he had galleries in both Malibu, California, and New York City. And in the year 2000, I had a client that was a lender in the art world. That lender gave loans and took in art as collateral for the loans. Michelle Cohen had a terrific relationship with my client for several years. He had a revolving loan, as many galleries have, under which he pledged his inventory for works of art, his inventory of works of art for the loan, and was able to borrow money that he needed for transactions. After several years of successful dealings, between the revolving loan he had and some others, he decided he wanted to go into some new types of deals. So he proposed to the lender a venture deal. The venture deal being that Michelle Cohen said, I have somebody who has Picasso who wants to sell it. He'll take $3 million. I also happen to know a buyer who will pay $4 million for that. So you, Mr. Lender, if you lend me the $3 million, you and I can split the profits 50-50. Each get $500,000. This was his venture deal. So they entered into that deal because they had a good relationship. They had a lot of trust that had been established over many years, and the first deal went very well. He then proposed another one and a few more. So they had 4 more deals out there. Same thing. The 4 more deals involved 2 Picassos and 2 Chagalls. And with the revolving loan that he had and these venture deals, he was then indebted to my client for $10 million at that point. And he promised that these deals would be done very quickly. But time dragged on. He wasn't paying on these deals, and he didn't return the principal, he didn't return the profits. He told the lender that he'd completed the transactions, but he just hadn't been paid. He said the buyers needed more time to pay. And after a couple of months of those excuses, the client came to me, and we investigated and became very concerned that what we were seeing here was a fraudulent scam. Then Michelle Cohen bounced 2 checks for millions of dollars to the lender. And at that time, we realized it was time to file a lawsuit immediately. We sued Cohen, alleging fraud. We sued in both Malibu and New York simultaneously. We attached all of his assets. We got an injunction against him, prohibiting from transferring any of his assets to any other. So they were out of reach to us. But as soon as we filed and the news hit the paper, other art dealers all over the world started announcing their own realizations, saying, wait a minute, I gave Michelle Cohen my Picasso. I haven't gotten paid, I haven't gotten it back. And some others said, wait a minute, I gave him $3 million to go buy a Chagall, and nothing's happened. Within a week, another dealer filed a lawsuit against Michelle Cohen, and within a few days, the losses, as they came out in the press, totaled about $40 million. And when all the dust settled, the fraud was estimated to cost about $50 to $100 million. Michelle Cohen walked away with that money. In our lawsuit, we actually obtained a court order against Michelle Cohen requiring him to show up at a deposition. And we waited on the deposition date in the conference room, and his lawyer came, and we waited there for Michelle Cohen to show up, because we needed to find out some specifics about what had gone on here. We didn't have many facts other than we know we lent him the money. So we waited 10 minutes and no Michelle Cohen. So his lawyer called him and had to leave a message. So we waited 20 minutes, still no Michelle Cohen. We waited 30 minutes, still no Michelle Cohen. And after 45 minutes, his lawyer received a call from him saying he was unable to make it to the deposition. This is a court-ordered deposition. You don't just say you're unable to make it to the deposition. That's contempt of court. Well, that, of course, was the last anyone saw of Michelle Cohen for a couple of years. He fled from the U.S. Some said he went to Cuba. There were many rumors the FBI and Interpol chased him. More than 2 years later, in May 2003, he was finally arrested in Brazil, and he'd apparently been in Brazil for some time with his wife and 2 children. The U.S. wanted him extradited. Now keep in mind, this is 2003, so this is not long after the 9/11 terrorist attacks. The U.S. was wielding a hefty club on trying to get things such as extraditions. But in Brazil, Brazil had a law that said, if you have a child when you're in Brazil, you're not subject to their extradition law. Well, as it happened, Michel Cohen was probably well versed in that law because he and his wife happened to have a child when they were in Brazil. So the Brazilian government was in a difficult position. Do they acquiesce to the U.S. pressure to extradite him, or did they stay true to their own laws that created an exclusion from extradition? So what happened? Well, in January 2004, a few months later, there was a press announcement that Michel Cohen had escaped from custody. And he's not been arrested since. So during our lawsuit, I happened to obtain his bank records and his brokerage account records and found that I had tracked $27 million going to a Swiss bank account. And interestingly, I find this very interesting, whether there was really premeditation here or not. There were a lot of statements that Michel Cohen had engaged in commodities futures transactions, he'd gotten into that. But one, he sends $27 million to a Swiss bank account. Two, is doing business as his name. You know, a lot of companies or people do business under another name. His was Pentimento. Now, many of you may know that Pentimento is when the underpainting starts to show through to the surface after several years. I found that very telling. So going back to the law I described earlier about dealers having the right to transfer good title, Michel Cohen was a dealer. And so imagine what happened. Imagine the chaos here, where he sold one painting to 3 different people, got money from all 3 people. Who's the owner? What about the seller who never got paid any of that money? What are his rights? Similarly, my client was a lender, had all sorts of works of art that were collateral. Who owned those? Them, or the people that had possession of them? So you can imagine there were many lawsuits. I was involved in several of them. It was very complicated and difficult to resolve because every party in those lawsuits, whether plaintiff or defendant, was a victim of the scandal. And like the court said in the quote I quoted earlier, the villain had left the stage permanently. He left everyone else to clean up the mess. So let me talk about another case. Now I'm referring to the notorious business dealings. This fast forwards a couple of years, several years. The notorious business dealings of the Salinger O'Reilly Gallery and its principal, Lawrence Salinger. Lawrence Salinger opened a gallery in 1974. In the 1990s, the gallery moved into an impressive space on 79th Street in New York, and in 2005, moved to an even more impressive space on 71st Street between Madison Avenue and 5th Avenue. It had 6 floors, 25,000 square feet, 4 exhibition floors. I recall going there one time. There were John Constable exhibition on the first 2 floors. On the 3rd floor, there was an Impressionist exhibition. On the 4th floor was an emerging artist. On the 5th floor was his private gallery, Salinger's private gallery, to show people things to sell. They had a basement that was full of hundreds, if not thousands, of works of art, old masters, Hudson River School, French Impressionists, 20th century American works, many others. By 2005, the Salinger O'Reilly Gallery had created the impression that this gallery was one of the most successful and most endowed galleries in the world. In fact, its bank, First Republic Bank, even posted an ad on a huge billboard in Manhattan touting how Salinger O'Reilly Galleries was one of its clients and was a huge success story. Behind the scenes, however, the gallery already was deeply in debt in 2004 and 2005. When the gallery moved to the extravagant facility in 2005, its debt problems became very serious. First Republic Bank pumped tens of millions of dollars into the gallery to keep it afloat. The bank also held a security interest in the gallery's entire inventory of art. Because, keep in mind, this is what's going on behind the scenes. In the outer world, nobody knows that there's anything wrong with the gallery or there are any financial problems here. There's an individual named Earl Davis. Earl Davis is the son of a very famous American painter named Stuart Davis. You probably have heard of him. Earl had a 20-year relationship with Larry Salinger in the gallery, and they had a terrific relationship over that period of time. 20 years, I don't know, seems to be the magic number. He consigned hundreds of paintings that he had gotten from his father. These were all paintings created by the well-known Stuart Davis. In 2004 and 2005, however, he wasn't getting a lot of information from Larry Salander of the gallery. And he asked about what was the status of all the works that he had left there on consignment. The gallery dragged its feet in responding and did return a few works. But in early 2007, Earl Davis had discovered that approximately 100 of the most valuable works from his father were missing. He learned from gallery personnel that they had actually sold 75 of them over the preceding 10 years and never paid him a penny. Never even told him about it. So in May 2007, Earl Davis filed a lawsuit against the Salander O'Reilly Galleries and Larry Salander. I represented Earl in that lawsuit. We obtained an injunction against the gallery, requiring the gallery to return all of the Earl Davis works of art that they had. We were able to retrieve about 15 of them. 10 others were simply missing, and of course we had learned that 75 of them had actually been sold. And they had been sold for $10 million, but the gallery said, we're out of money. We don't have the $10 million in it. In fact, the gallery had sold those works at fire sale prices. The real value of those works of art was really closer to something like $30 million. So after we sued the gallery, it was the same story again. Other consignors and creditors began to file lawsuits against the gallery. First news publication to pick it up was the Main Antiques Digest. And by September 2007, new lawsuits were being filed every day because people learned that other people had sued the gallery, they got concerned, and there was a problem, they weren't getting paid. And so in October 2007, an entity named Renaissance Art Investors, or RAI, filed a lawsuit. Now, RAI had entered into a joint venture with Salander O'Reilly Galleries. We have the joint venture come back again. And much of the funding actually had come from the gallery's own bank, First Republic. The entity that was set up in the joint venture was in the business and did purchase many Italian Renaissance works of art. But in mid-2007, RAI had discovered that the gallery had sold some of the joint venture art without disclosing the sales to RAI, without paying RAI any of the proceeds. In October 2007, RAI obtained a temporary restraining order, or TRO, that restrained the gallery from transferring any more works of art that were assets of the joint venture. But 2 days later, according to RAI anyway, a moving truck was outside the gallery. It was loading up and moving out other works that RAI claimed were subject to the TRO, a lot of this Italian Renaissance work. The next day, RAI went back to court again and sought a second TRO, and was also successful in getting a court order to padlock the gallery to prevent Larry Salander or anybody who worked there from even getting into the gallery. News photographers were there, and in this photo you can see Salander and his wife and his son, who's trying to prevent photographers from taking pictures. At the next TRO hearing, in RAI's lawsuit, you could barely find room in the courtroom to stand. It was flooded with dozens of lawyers. There were probably 50 to 100 lawyers there. I was one. Because our suit was in federal court, this suit was in state court. They were trying to get rights that we had already asserted in federal courts, and we were there to protect our clients' interests. But there were probably 50 to 100 lawyers. Probably the worst nightmare for everybody in this room, to be in a room with 100 lawyers. But that's the job of a judge. Then, of course, came the bankruptcy, and 18 months later, the Manhattan District Attorney indicted the gallery and its principal, Lawrence Salander. Salander ultimately pled guilty, and he's currently serving a 6-year jail term. High-profile lawsuits were brought by various celebrities, including John McEnroe and Robert De Niro. McEnroe actually had been a longtime friend of Salander's, and apparently apprenticed at the gallery after he really retired from tennis. Subsequently, he was defrauded by Salander, and I'll talk about that suit in a minute. Also, Robert De Niro's father, you may know, was a painter, and De Niro became a friend of Salander's and consigned many of his father's works to the gallery. The gallery sold some without paying De Niro and shipped others to a gallery in Italy. De Niro brought a lawsuit against the Italian gallery in New York and then filed a claim in the bankruptcy against Salvador, the Salvador Riley gallery. There were numerous cases brought by galleries' longtime friends, by their longtime business partners. Cases were filed by dealers, artists, families of deceased artists' estates, and many other creditors. Now, in many cases, it was exactly what we're talking about here. It was consigners who would consign things to the gallery and lost their art, because the gallery, of course, had the rights to transfer it. Now, one issue that arises, there were many artists and artist heirs who would consign things to the gallery. So there's one piece of the law I haven't told you about. That is when an artist in New York, this is a New York law, when an artist or an artist heir consigns things to the gallery, there's a special law that says that work of art that belongs to the artist must be held in trust by the gallery for the benefit of the artist or his heirs. And if any of those works of art are sold, the sales proceeds must be held as trust funds in trust, also for the benefit of the artist or the gallery. Also, that art and the sales proceeds are not supposed to be subject to the claims of creditors. The problem is, when you have a gallery like Saunders that just decides not to pay attention to the law and not obey the law had no teeth. There were no penalties whatsoever for enforcement provisions of the law, even though it's a statute. It did not require the galleries to segregate proceeds from the sales. Now understand what happens in these circumstances. So when you consign a work of art to a gallery, that's your work of art, and particularly for an artist, that's their work of art. The gallery is entitled to usually a commission. That commission is somewhere between 10 and 50% for artists, it's usually 50% for other collectors who consign things, it's usually a lower percentage, 10, 15, 20%. So the galleries, when the gallery sells that art, sells it for $100,000, most of that money doesn't really belong to the gallery. It belongs to the consignment. And unfortunately, what happens for galleries is they sell the art, the money goes into a bank account, and it's used for whatever they need to use it for, which ends up being a lot of their operating costs and things like that. They're not required to segregate those funds. Well, the non-segregation of the funds is what really ended up costing so many of the consigners in the Salvador Riley galleries. Because think about it, even though the funds from artists and consigners were supposed to be trust funds, if it's all commingled together, how do you know what money belongs to whom? So Salvador sold all of this art, didn't pay the consigners. So after this Salvador Riley gallery debacle, I chaired a committee of art players in New York, and we decided that it was necessary to remedy the law to try to put some teeth in it. Our committee drafted and submitted to the New York State Legislature amendments that gave it teeth, including adding criminal penalties to it. And I'm happy to say that the amendments were passed by the New York State Legislature and signed into law by Governor Cuomo in 2012. So hopefully some of the tragedy that arose out of the Salvador Riley gallery debacle will be prevented in the future. Let's go back again to what we had started out with about who has the rights. The consignor has the rights, gives it to the gallery, and the gallery sells it, and oftentimes the buyer has better rights. So here, where there was no money left in the gallery, there were consigners who said, I want to go after some of the buyers. What happened for Salvador, as I said earlier, he sold some things at fire sale prices. Remember when I said a buyer could buy things and have better rights, the buyer has to pay good value and has to not be aware that there's anything nefarious about the transaction. And remember, when the buyer is a merchant, they have a higher standard of due diligence. So when Salvador was in desperate condition, as I said earlier, he was selling things at fire sale prices. In December 2005, Earl Davis was not aware that Salvador was selling things at fire sale prices. And he tried to get his works from Art back, as I said, and he couldn't do so. He wasn't getting it back, so he instructed the gallery to stop selling all of his work. Keep everything, get it all back in the gallery. He wanted it back, he wanted to do an inventory. But without his knowing it, the gallery continued to sell his works of art. And between January 2006 and May 2006, a wealthy buyer named Joseph Carroll engaged in a series of transactions in which the gallery sold to Carroll 44 works created by 12 different artists, including 16 Stuart Davis works of art. Carroll received no documents showing that the gallery actually owned the Stuart Davis works, and he never asked the gallery whether they actually owned them. In fact, shortly after Carroll bought some of these, another dealer told Carroll that one of Salander's directors had told him that Stuart Davis works that Carroll had purchased had actually come from Earl Davis personally. But despite hearing that, Carroll did not ask why the gallery had prepared documents saying it was the owner. The other dealer also said to Joseph Carroll that for one of the paintings that Carroll had bought, that dealer had been told that Earl Davis did not want to sell that painting. Carroll nonetheless took the position that he assumed that the gallery actually owned those Stuart Davis works. So Earl Davis had to bring a lawsuit against Joseph Carroll to recover the many Stuart Davis works that Carroll had purchased from Salander. In the lawsuit, the court found that the prices Carroll paid were suspect. Now see what you think. For example, Carroll purchased 2 Davis works for $600,000. But he reconsigned one of those back to the gallery the same day for $750,000. He subsequently consigned that. It didn't sell, so he subsequently consigned it to another gallery at a sale price of $1.2 million. And then a few months later, he consigned it for $2.75 million. So he bought it for $600,000. Excuse me. But he apparently believed the value was greater than $2 million. Also, he brought it, there was a series of these. I'll just give a couple of examples. He also purchased a group of 4 Stuart Davis paintings from Salvador galleries for $120,000. And resold them back to the same gallery 5 months later for $650,000. Earl Davis's expert in the case had concluded that Carroll had purchased these works for probably 31% of their value, or a 69% discount. Salander and the gallery, of course, never paid Earl Davis any of that money, even though it was fire sale prices. Joseph Carroll, of course, was an art dealer. You'll recall that he had a heightened duty to investigate. So in the Earl Davis lawsuit against Carroll, the court explained that the bargain basement prices offered by Salander, along with a battery of irregular and suspicious issues pertaining to Salander's ownership and right to sell the Davis works, constituted red flags that triggered a duty of heightened inquiry on Carroll's part before any consummation of the 2006 transaction. The court further ruled that no reasonable juror could examine the provenance documents Carroll had and conclude that Carroll believed in 2006 that the gallery had owned the Stuart Davis works. So Earl Davis won that case. Here you have a seller who's the owner who actually trumps the buyer, even though the law generally works the other way. It doesn't work the other way. If you don't pay value, it doesn't work the other way. Particularly if you're a dealer and you know there's something wrong with this transaction. Those are the red flags. Now, I told you I'd talk about the McEnroe case, too. As I earlier said, or may not have said, Salander, in this case, took a page out of the Cohen book, playbook, and entered into a venture deal with John McEnroe. In that deal, Salander and McEnroe were to be equal partners in acquiring 2 Marshall Gorky paintings, Pirate 1 and Pirate 2. Salander purchased the 2 paintings at a Paris auction for $4 million, and McEnroe gave him $2 million before the sale, half the purchase price as part of his deal in this venture. What McEnroe did not know, however, is that Larry Salander also entered into the exact same deal with another person named Morton Bender. In that separate deal, he said to Morton Bender he would also be a 50% owner of these 2 Marshall Gorky paintings. And Morton Bender gave him $4 million, $2 million of which was supposed to be Morton Bender's share of it, and $2 million he loaned to Larry Salander so Larry Salander could be part of the deal. So Salander obtained $6 million for 2 paintings that he bought for $4 million. Salander told both Bender and McEnroe individually that Salander would hold a 50% interest, and each of them would hold a 50% interest. So we have 150% interest, which is a little high. McEnroe actually took possession of one of the paintings, of Pirate 1. However, without telling McEnroe or Bender, Salinger entered into a deal with the same Joseph Carroll to trade Pirate 2 to Carroll. The trade was to be in exchange for 2 paintings from Carroll, one of which was a Stuart Davis painting known as Bouchard, and the other a painting known as Kabuki Tetrad. Carroll had acquired Kabuki Tetrad several years earlier for $400,000 and acquired Bouchard from Salinger together with 11 other works by paying Salinger $665,000 for all 11 works and giving Salinger one other work. So Carroll acquired Pirate 2 for something less than $1 million, even though Salinger bought it for more than $2 million. Again, this is Salinger trying to get whatever money he can, giving things away at fire sale prices. Salinger, of course, did not tell Carroll about the double dealing ventures he had entered into with McEnroe and Bender, but instead told Carroll that the paintings were owned by an entity called the Seven Salinger Children Group. Now, although Carroll had been doing business with Salinger for many years, he'd never heard of this group. And the court found that Carroll should have investigated this purported group's existence, because if he had, he would have found out that the group did not exist at all. The court also found that the bargain sale price Carroll paid should have alerted him to red flags concerning the transaction, particularly since Carroll himself claimed that he was at the Paris auction when Larry Salinger bought them. As the court said, Carroll acquired Private 2 in a grossly undervalued transaction in which he chose to make no inquiry as to Salinger's authority to sell them, despite behavior on Salinger's part which marked a departure from their normal course of dealing. By going forward with the transaction, despite these red flags, Carroll did not observe the reasonable commercial standards of the art trade. So therefore, the court ruled that Morton Bender and John McEnroe get their paintings back. Of course, then they have to resolve, since they're both supposed to be joint ventures in this, how they're going to do this and divide it up. But they did that on their own. So that shows you a little bit about consignment risk and why you need to be careful. Sellers need to be careful because oftentimes buyers can trump the rights, and every once in a while we have these circumstances where buyers really are not entitled, even though the law generally favors them. So just as sellers need to beware of the pitfalls of consigning art to dealers, buyers need to be careful too about whether the dealer has the right to sell it. The buyers also need to be careful about whether the work of art they're buying is authentic. So I want to shift gears now and talk about authenticity. There's increasing concern, many of you may know this, in the art world today, that many qualified authenticators, experts and scholars, are refusing to give authenticity opinions. The reason this is happening is because authenticators are getting sued with increased frequency for giving those opinions. Most of the suits fail. Rarely do the suits have merit. But just by having to pay enormous legal fees in defending against these suits, the authenticators say, we're not doing this anymore. We're dropping out of the business. Authentication is extremely important. It really, in many ways, is what drives the art market today, and always. Because the authentication opinion provides that level of assurance that the work of art is, in fact, what it's said to be. It's important for sales. At the very least, it establishes the price point at which a work of art will sell. It's important for a donation to a museum to establish what is the tax deduction for it. You've got to know whether it's authentic, you know what the value is. It's important when you value works from a state, when an estate is being settled. Again, you've got to know what is an authentic work, what is not. Reliable authenticity opinions also reduce the likelihood that fakes and forgeries will flood the marketplace. Let me talk just briefly about how authentication is done. There are generally 3 methods. You can look at documentation that establishes the provenance. So if you've got documentation that goes from the artist to the current owner, and there's a stream of documents, that's pretty good evidence. There's forensic or scientific testing that can sometimes tell us whether a work of art is what it purports to be. And then there's connoisseurship or stylistic inquiry. Let me talk about each briefly. Documentation, if itself is authentic, can be very helpful in assessing the authenticity of the work. But oftentimes it doesn't exist, and sometimes it may be forged. So let me talk briefly about a situation with the recent Nolder Gallery events, which many of you may have heard about. Nolder Gallery had been a gallery, major gallery in New York, been in business for 165 years. Over the past 15 years, Nolder sold approximately 40 paintings that had obtained from an essentially unknown Long Island dealer. The paintings were sold as paintings by Jackson Pollock, Mark Rothko, Willem de Kooning, Robert Motherwell, Sam Francis, Franz Klein, and others. The source of these paintings was a woman on Long Island named Glafira Rosales. And she was selling the paintings, she said, on behalf of two owners. One was a Swiss client and the other a Spanish collector. She further claimed that the father of one of those current owners had been a friend of the artist and obtained these works of art from the artist directly. She told Nolder, however, that one of the owners wished to remain anonymous, so she couldn't provide any documentation. She said the other owner, though, did have some documents and produced what purported to be documents certifying the source of the paintings. Now, unfortunately, those documents that were used to establish authenticity happened to be forged. There was therefore no legitimate documentation that could assist with any legitimate authentication, because all of these paintings were, in fact, this is unusual, because these are recent paintings. These aren't old Italian Renaissance paintings or old masters paintings. These are contemporary paintings. So you would hope there would be some documentation that would help out. But even in this instance, there were not. The real artist, as we all later found out in the press, was an individual painter, a Chinese immigrant in Queens, New York, who was painting these. He was paid about $6,000 for each one of these fakes. Glafira Rosales sold these fakes for amounts in the range of about $600,000 to the Nolder Gallery. And Nolder Gallery sold them for amounts in the range of about $6 million. In fact, some of them sold for even more. I was involved in a case where there was an alleged Jackson Pollock that was sold for $15 million. In total, Nolder Gallery paid Glafira Rosales more than $20 million, and Nolder in turn sold the paintings for more than $63 million. Many of the buyers later sued Nolder, claiming that the paintings were fake. I was involved in one of those. Ultimately, Glafira Rosales was indicted, and as I said, the actual artist was found and located in Queens, although apparently now he's gone back to China. And Glafira Rosales' alleged accomplice, Carlos Bergantinos Diaz, you may have read about this just recently, was just arrested in Spain on Easter Sunday, just a few weeks ago. So the Nolder debacle is an example of a situation in which documents, the only documents existed, even for contemporary art, turned out to be forged documents. So that brings us to the next method of authenticity or authentication, and that is forensic testing. Now, there are many techniques that have been developed over the years that can be reproduced, and these are forensic, very scientific tests. In the Nolder Gallery, one such test was used in the Nolder Gallery cases. Several buyers retained an expert who analyzed paint that had been some of the paintings they purchased. In one of his analyses, he took 2 paint samples from a painting that was supposed to have been painted by Jackson Pollock, and he analyzed those paint samples against investigated and did research on paint that had been on the market over different periods of time over the years. And he determined that from the paint samples, that the paint that was used was first developed in 1957, was first patented in 1962, and first on the market in 1970. Of course, Jackson Pollock died in 1956, so we have a bit of a problem there. The paint was created after Pollock purported to paint this painting. So the evidence was used, that scientific evidence, to challenge the sales by Nolder by many of the people who were bringing suit against the gallery. The third method of inquiry is stylistic analysis or connoisseurship, and this is probably the most common method. Although the most common, not just anyone is qualified to do it. In very few are qualified to really do it well. It takes intense detailed knowledge and painstaking analysis over many years. These are often scholars. These are people who specialize in individual artists, who get to know the artist, how they painted, what they did, what sort of canvases they used, boards they used, and it takes a lot of detailed knowledge. So this detailed knowledge is extremely valuable for the art world today. And it's also the fact that this highly qualified subjectivity that they have makes them vulnerable to lawsuits. Because it's easy for anybody to go to a scholar and say, oh, you can put too much weight on this one factor, you didn't consider this other factor enough. And it's the risk of frivolous lawsuits, as I mentioned earlier, against authenticators, that's silencing the opinions of highly qualified experts, even though these are the people right now we need to hear from, because this is becoming a crisis right now. And again, using the Nobler Gallery situation as an example, Nobler Gallery actually went to the Pollock-Krasner Foundation for the authenticity of one of the works of art that was an alleged Pollock. But the foundation declined to give an opinion because of the risk of being sued. Had the fear of lawsuits not silenced some of the experts, it's possible that the Rosales scandal might have been uncovered much sooner. Let me talk a little bit, to put this in context, about a lawsuit against the Andy Warhol Foundation. It provides a good example. The lawsuit was brought by an individual collector named Joe Simon Whelan in 2007. An issue was a silkscreen, a self-portrait Warhol took of himself in a Times Square photo booth in the 1960s. And there were two different series of silkscreens made out of it. One was made in the Warhol factory in his studio. The other was a 10-edition series that was made in an outside fabricator. People disagree about whether Warhol actually authorized the outside series of the 10-edition series. And an issue in the lawsuit was one of those from that 10-edition series. In 1987, this particular work was sold, and at that time, the Warhol Foundation, which was in the business of authenticating works of art, stamped the silkscreen, looked at it in 1987, many years later, and stamped it with Warhol's signature, saying it was authentic. And a year later, that work was sold again. And oftentimes when people go to sell things, they do try to check this authenticity, so they go to these authentication firms and ask for it. And then the Warhol Foundation and the chairman of the Warhol Foundation confirmed the authenticity and even inscribed right on the side of the painting, on the edge, I certify that this is an original painting by Andy Warhol, completed by him in 1964. The work changed hands several times, and Joe Simon Whelan purchased it in 1989 for $195,000. And 11 years later, in 2001, he wanted to sell it. He submitted it to the Authentication Board. At this time, the board denied the authenticity of it. It stamped on the back, as you see there, denied. Simon Whelan accumulated a lot of evidence. He was surprised, got together a lot of the provenance documents, went back to the board and said, here's support for why this is an authentic work. Again, they looked at it, they looked at the evidence and denied it. And hence, the lawsuit that arose out of this is called double denied. You see the two red denied stamps stamped right on the silkscreen, by the way. Simon Whelan sued the Warhol Foundation and the Warhol Foundation Authentication Board, alleging that they had unlawfully conspired to refuse authentication of his work and works and many other works. He contended that the foundation and the board did this intentionally to inflate the value of Warhol works that they sold and make other works of art that were out on the market worthless. Unfortunately, the suit dragged on for many years, but Simon Whelan voluntarily dropped it because he ran out of money. The suit itself, however, also cost the Warhol Foundation $6 million for damages. Big legal fees, big defense. The fees were so high that the continuing risk of lawsuits caused the Warhol Foundation to decide it was getting out of the authentication business. And it closed its authentication board in October 2011. So if you want to check the authenticity of your Andy Warhol work you just purchased, you're out of luck according to the authentication. Similar concerns caused other boards to do the same thing. The Pollock-Krasner Foundation, as I said, does not authenticate works of art anymore. Roy Lichtenstein Foundation doesn't do it anymore. The estate of Jean-Michel Basquiat does not do it anymore. The fact is that the risk of these expensive lawsuits is silencing the authentication experts. Nearly all of these lawsuits are either dismissed or result in the decision in favor of the authenticators. Yet the authenticators cannot afford the legal fees in having defense against them. So rather than even take the risk, they say, I'm just not doing this anymore. It's not just boards, it's individuals too. It's an increasing trend that's threatening the integrity of the art world and many of the important art institutions. So recognizing the alarming rate at which scholars and artist foundations are dropping out of the business of authentication, the Art Lawyers Committee in New York, of which I'm now the chair, created a subcommittee in 2012 to evaluate the problem and try to find a solution. And we came up with a multi-pronged approach, but the core of that approach is legislation to try to incentivize authenticators to get back into the business. So what does the legislation do? It first defines who is an authenticator that's qualified for the protections of the legislation. And it identifies two types of authenticators that we talked about earlier. Those who give opinions about whether a work of art is authentic or not, such as foundations, individual scholars, catalog raisonné groups. As you probably know, catalog raisonné is supposed to be a catalog of an artist's entire body of works. And so if a work of art is not included in the catalog raisonné, the assumption is that it may not be an authentic work of art of that artist. The other group of authenticators is what we talked about earlier, the forensic or scientific testers, the scientists. So it covers both of those, provided that that testing is used as a basis for an authentication opinion. The authenticator must be someone recognized in the visual arts community or the scientific community as having expertise in the particular artist or the scientific technique used. An authenticator covered by the legislation, however, does not include a person who has an actual financial interest in that work of art, such as a dealer. So a dealer says, this is an authentic work, the dealer wouldn't be protected because he's getting a commission out of that sale. So it doesn't protect people who have a financial interest in the work of art or the transaction, except to the extent that they're paid just to give authenticity. Once somebody qualifies an authenticator, here's the protections that they get. First, it requires a person who's suing them to state facts very specifically in the complaint, in the original pleading document. This is done, this comes up in a couple of other contexts, but it's done because if the claim is flimsy at best or frivolous at worst, its lack of merit is going to be exposed by the fact that there are no actual facts to support the claim. They're just broad allegations. Second, legislation also requires somebody bringing a claim against authenticators to meet a higher standard of proof. Usually, when you go to a jury trial, the jury has to decide whether it's more likely or not that one side wins over another. In these cases, this legislation requires the person suing to prove their case by what's called clear and convincing evidence. And the third element of the legislation that protects it, probably the most critical, is that it awards attorney's fees if, in fact, the authenticator is successful, and to the extent the authenticator is successful in defending against the lawsuit. As we discussed, this is really the crux of it, because it's those attorney's fees that are causing authenticators to drop out of the market. The proposed legislation has sponsors now in the New York State Senate and in the New York State Assembly. It's been voted actually out of the Senate committee and is now up for consideration before the full Senate. We're working on the Assembly. I'm going up to meet with Sheldon Silver's office on Monday. We've received letters of support by many, many constituents in the art world, the Guggenheim Museum, the Art Dealers Association, the Art Appraisers Association of America, and many, many others. National Academy Museum. We've got a lot of support for this because everybody is concerned about this being a development crisis. So we're hoping that it will pass, and hoping that it will bring authenticators back into the business of authenticating. So, thank you. Thank you for inviting me to speak today. I hope I gave something. I hope it wasn't too boring. I didn't want to make it too legal, but I'm open to answer any questions if some of you have questions. Yes?
Your authentication Rago auction house, when they authenticate something, is everything exposed to an expert of the risk
There is a risk. I really should let Miriam answer this question as to Rago specific practices. But there is a risk. But also, sometimes when things are sold, there are different ways that they're described. Sometimes they're said to be by an artist. Sometimes they're said to be by the school of an artist. Or sometimes they're said to be attributed to an artist. And those are different categories usually in auction catalogs that qualify to what extent of certainty is there. But I'll let Miriam talk about what they do here. I'm afraid I can't answer that. I'm sure they do a good job.
There is a risk, and we do all the due diligence we can, whether it's getting it in front of the proper authenticator or by another means. If the buyer finds out on the other side of the transaction that it is, in his opinion or her opinion, not by the artist we thought it was by, then there are avenues to pursue to be made whole. We have terms of sale that has a limit. I believe the UCC limit is 5 years, 4 years. Is 4 years. That said, as an auction house, we think our reputation is standing behind the pieces we sell, and we do everything possible. Should that come up, happily, it has rarely come up. I can think of 2 examples where we've had to follow up since I've been here, and that's been through 99, to make sure that the parties are whole, and hopefully that's what insurance companies are for.
Yes.
Aren't there certain authenticators that's the end, and you can't go any further than that? They say it's so, it is so, because you really need to challenge that?
Well, sometimes that's what happens, particularly with the authentication boards. And you see more of this. Even in Europe, there's some authentication boards where these are people often that are put together as a group who have particular knowledge regarding a specific artist. So sometimes it'll be people who actually knew the artist, particularly for contemporary art. Sometimes Earl Davis helped with the catalog raising it. He often saw what his father was doing, so he'd be wonderful first-hand knowledge. So it depends on the circumstance. There are sometimes people that are supposed to be the definitive knowledge. But, so look at the situation here. That was true really with Basquiat, with Colin Krasner, and with Warhol. But now those prime authenticators are not doing it anymore. So now you're leaving it to people who are maybe less qualified. And it's difficult. You have authenticators even for older works of art, Italian Renaissance. So obviously they weren't around when the artist was working. And these are people that are usually scholars that learn their trade through art history classes and really studying an artist's work over a period of time. And some of those become the most highly regarded expert for a particular artist, but oftentimes they're a true
Do you get involved with any cases dealing with the illegal movement of cultural heritage pieces between countries or stolen artwork?
Sure, yeah. In fact, I had a major case involving antiquities. Some of you may know the issue that the Getty was dealing with several years ago. Marion True, who was the curator at the Getty, was actually indicted in Italy and actually went to trial. But that involved a lot of antiquities that were stolen or looted from a lot of the sites. There are a lot of laws against this. There are patrimony laws, there are theft laws that the U.S. government enforces. So there, in fact, are import and export laws. And the U.S. Customs Service looks very carefully at art that comes in and out of the country. So there are many different ways that things like that arise. But there have been huge lawsuits. I mean, many of the major museums have had to give back many works back to the originating country. Sometimes even when there was a legitimate deal that was arranged at the outset. The work wasn't really looted, but the country bought it back because it's really their cultural heritage. So that's an ongoing, significant ongoing issue. Yes?
You gave a lot of examples where the seller or the consignor is vulnerable and the buyer is a better bet to win unless it's a dealer who's to a higher standard. What do you not asking legal advice, what would you recommend to a seller or a consignor to do in order to protect themselves from having to go through all, losing it to somebody and then having to go through all the lawsuits what can they do to protect themselves ahead of time?
It's an excellent question. So, many things. First off, particularly if this is a significant work of art, it has significant value, hire a lawyer. And I'm handing out cards later. No, but there are other things you can do too. Stay on top of the deal. Don't just give a work of art. And this happens many times with consignments, usually for dealers. If you consign things to an auction house, you know when the sale comes up. The sale comes up on a specific date, it either sells or doesn't sell. But when you consign things to a dealer, you give it to them over time so that they can shop it around. Sometimes they'll actually send it out to other dealers and things like that. So you really have to stay on top. Check in with the dealer. Where is it? Go and see it. Go down to the gallery, make sure you get to look at your work of art from time to time. There's also something, I wasn't going to get into this, but I'll explain a little bit, called a UCC1 financing statement. So what is that? It's a little like when you buy a house and a bank takes a mortgage out on your house. You know, when you buy that house, you hire a title company to go look at, do a title search. And in the title search, it not only checks whether there's good title, but it'll also tell you whether there's a mortgage or a lien against that house. In the art world, or it's not just the art world, in all of business, there's something similar called a UCC1 financing statement. What it means is you can file, if you have a security interest in any piece of property that is on consignment, you can file a UCC1 financing statement with the county clerk. And what that's supposed to do is put any potential buyer on notice that there's somebody out there that has an interest in that particular area. I won't get into the details. It's rarely used in the art world because it never has been used. People don't do it. When I had the Michelle Cohen case, right after the Michelle Cohen case, everybody said, art on a handshake, deals on a handshake in the art world are over. People are now going to be filing UCC1s. So that lasted for about 1 or 2 years, and then memories are short, people forgot about it. It's not a practice. It's used a little more than it ever was. There are some problems with it, many problems. But it's worth trying. And so when you consign a work, particularly if it's of significant value, you can file a UCC financing statement. It's not hard to do. If you go to your Secretary of State, that's where they're filed with the state and the county clerks. It costs almost nothing. It's a very simple form to fill out. What it does is put the world on notice. So on the other hand, if you're a buyer, and you go to a gallery and you want to buy something, also look to see whether there's a UCC1 financing statement out there for that particular work of art. It's got the name and the title. Or if there are financing statements out there generally against the dealer, take a look at what's out there. You're spending a lot of money. For some reason, when people spend a lot of money in the art world, people buy houses for $500,000, $1 million. They hire lawyers, they do title searches, all sorts of things. People buy art for $500,000, $1 million, sometimes multi-million dollars. Lawyer, they do it on a handshake. This is how it's always been done. It just is baffling to me. But the answer is be diligent, and to the extent you're talking about high value things where there's a cost benefit, hire a lawyer to protect your interests. You enter into a specific consignment agreement that details what the obligations are. That's another important aspect of those transactions. Yes?
Is it important for us in the audience to know what the legal definition of consignment is?
No. There's, I don't want to make this too complicated. There's something called the Uniform Commercial Code, and the Uniform Commercial Code, which applies in most states, almost every state. They have a definition of consignment, and it's possible that a work of art or that a deal you have, a transaction you have with a dealer may not even qualify as a consignment specifically under that definition. Nonetheless, many of the same rules will apply. So that's why I say it's not critical that you really understand whether it's a consignment per se. It can be what's called an entrustment. As long as you hand over possession of the work to a dealer with the intent either to sell or to take care of it, you're still largely protected along the same lines. And you can still file a UCC1 financing statement. So there are different types of transactions that all have similar protections. Some of them are specifically defined consignments, some are not. Yes?
Given the magnitude of the problems on Wall Street and everything else going on in legislators in Albany to the problems of the New York City Art Law?
Well, the legislation that we proposed a couple of years ago did pass, and that was important legislation because it did protect artists and artist heirs in their relationship with their dealers. It included things like an attorney's fee provision. Legislatures tend not to like those. In this country, generally everybody pays their own attorney's fees. Unlike in England, usually the attorney's fees automatically get awarded in a lawsuit to the person who wins. In this country, that's not true. Win or lose, you still pay your own attorney. So the legislation that allows attorney's fees to be shifted to the winner is a little unusual, but the legislature in New York went along with that, and Governor Cuomo signed it into law. We're fighting on this one now. As I say, the Senate in New York is in favor of it. I'm hoping, they haven't voted on it, but it's gone to the Senate. The Assembly, they've asked some questions, so we're doing some pushback. Okay, one more. Huh?
You have a couple of experts here. We both have PhDs in American art, and we both work for one of the leading dealers in New York. So I would say with the authentication issue, one thing people are probably not aware of, so this is not a question, it's an amplification of your very entertaining lecture, an information-filled lecture. Issues of experts looking at art and then having an absolute say over it are fraught with problems. I have authenticated things. I did my doctoral dissertation on an artist when no one else has done any research or written on that artist. Now, most of his work is lost, but in the 15 years I've worked on that artist, I've authenticated 4 or 5 paintings by him, including very recently. My implication is that there's no regulation of someone announcing they're going to do a catalog resume and then being the expert on that artist, even though they have no background, no expertise in that artist, or when catalogs resume are fielded, as many of them are, by dealers. Because the dealers are the people that have the money to hire scholars, to do the field work, but then works of art by that artist almost automatically get directed to them for sale. So there's some very interesting ramifications. I personally am delighted to hear you're putting into effect a law that would encourage people to authenticate. But I think it's very interesting the larger implications of the expert authentication issues. So I just thought I would mention that.
No, it's an excellent point. Keep in mind, yeah, exactly, authenticators are not perfect. And this legislation is not saying that authenticators are perfect. What's important is they need to speak. So if you have one authenticator that says yes and one that says no, you need to hear from both of them. You can't have people out there remaining silent in this situation. For example, in the Knoller cases, there were people apparently that Anne Friedman took these paintings to who said, if they put it in the pleadings, they didn't say no. But maybe some people had wanted to say no, and they just didn't want to risk reputation. It's hard to know. Let's see how it shakes out when the cases go to trial. But it's a good point. The other issue is authentication opinions. Sometimes they're not necessarily fraudulent. Sometimes there's misattribution. My talk was much longer, but it was too long already, so I took it out. But there's a case I had where I had a painting. It was supposed to originally be by Raphael, and then it was by Bertogio. Some years, this 300 years ago, we had a letter that said it was by Raphael. 100 years later, there's some letter that says it was by Bertogio, and then after another 100 years later, somebody said it was by Parmigianino, and then later a lot of scholars said, well, it's not by Parmigianino, it's a copy by somebody in the school of Parmigianino. Well, I don't think any of them were being fraudulent. There was just misattribution. You still, right, authenticators are not perfect, which is another reason why they shouldn't be sued. But you need all of them to come out with their opinions. Yes?
Clarification, please. Rules of law, you stated. Is that New York State only? Are there any federal laws? And what about international problems? In other words, conflicts of...
Okay. So, generally, these are not federal laws. This type of law that involves sales of goods, paintings are sometimes deemed to be goods, are usually state laws. This thing I call the Uniform Commercial Code it's called the Uniform Commercial Code because it's supposed to be uniform around the country. So most states adopt that Uniform Commercial Code and have the same law for these sales of goods. There are variations, so they're not always the same. State laws, what I talked about with New York State regarding the law that protects artists when they consign things to dealers, that's just the New York State law. Nonetheless, after that law was passed, originally, which was 20 years, the first version of it, 20 years ago or so, about 34 other states adopted a similar law. So sometimes the laws are the same from state to state, sometimes they're different. When you go abroad, you're talking about a very different situation. For example, authenticators. You probably heard about this. I assume authenticators have heard about this and shaking their boots. There was a case in France recently where a judge decided that an authenticator who was a scholar and expert was wrong. Not only did he say she was wrong, he fined her and he put her in prison. She appealed, and apparently some of that may be undone. So, laws are different in different countries. Absolutely.
So, now that he's scared Jesus out of you, please bid in our office.